Good day. My name is Martin Schweiger and I'm a patent attorney. I work internationally and I'm one of 5,000 FICPI members, one of the largest organizations for IP professionals in this world. Today I wanted to give you more information about the role and value of a patent attorney in protecting intellectual property. Before I'm starting to talk about the role and value of a patent attorney in protecting intellectual property, I would like to bust a myth. The myth being that we patent attorneys are lawyers. And that's simply not true. I mean, not entirely true, as I will show you now. So let's start with a lawyer, as opposed to a patent attorney. And the picture that I like to use for a lawyer is a horse. A horse is a very auspicious symbol in the Chinese culture, and it is represented by the character Ma, here. And you can see, here are the four legs of the horse, then there's the tail here represented in the symbol at the end. Then we have the hair of the head, is a mane, is also represented here. So this is a symbol of a horse, and lawyers like to be seen as horse characters, because the horse character stands for being energetic, passionate, upright and aspirant. There's even a teaching in the Chinese culture, the Wu Xing, the 5 elements, and in the 5 elements, the Ma, the horse, is the Huo, the fire. So the horse, the Ma, stands for zeal and passion, and this is how lawyers want to be seen by their clients and by their environment. Very different the patent attorneys, and this is a symbol that, or picture that I like very much, because it represents us patent attorneys. We are a mixture between an engineer here, the front end of this horse, and a lawyer up in the back. It's a nice mixture, right? And as you can see, there's a part of the brain missing in the patent attorney symbol, and that brain that stands for all the works that lawyers do but patent attorneys do not. For instance, we patent attorneys, we have no divorce cases, never ever. We never deal with stolen bicycle cases, we never have murder cases, and we don't do real estate transactions, among others. All what we do is we focus on just innovation and nothing else. So please, in the future, don't mix a lawyer with a patent attorney. Don't call us patent attorneys lawyers. I want to go to another area that is a bit similar. It's a medical area, and you all know your general practitioner, right? He's a medical doctor. And as opposed to a general practitioner, there is the surgeon, right? And this is comparable a bit to a lawyer and a patent attorney, because the surgeon does very specialized things, is more like a mechanic for cutting body parts of humans, while a general practitioner is a high empathy guy who works with the patients that sit in front of him. Actually, general practitioners are our surgeons' clients because they deliver the targets for the surgeon's work. So that's another picture that you can keep in your mind when you talk with a patent attorney. We are no lawyers, but we are patent attorneys, only innovation. Let's now look into how protecting intellectual property rights can drive business growth, because intellectual property rights are a big part of innovation. The first big statement here is that protecting your intellectual property assets adds value and helps to grow your business. And there's nothing that has not been examined by science, and there's a 2019 study produced jointly by the European Patent Office, EPO, and the European Union Intellectual Property Office, EU IPO, that found that small and medium-sized businesses which have filed at least one intellectual property right are 21% more likely to experience high growth afterwards, compared with similar firms without any intellectual property rights application in place. That's quite an important intermediate result. You can see the full study here at the EPO news. I've put the bit.ly link so that you can more easily find the source for this statement. So what you could think here is that just by filing any intellectual property right would promote you on a growth path. However, the processes to apply for, and I must emphasize here, to be granted, protection for your intellectual property assets are varied, often complex and difficult to obtain. In the first place, the application process can be lengthy. Then, without the help of a specialist patent attorney, you are likely to find yourself spending far too much of your valuable time on the application, and you may never complete the process. Because even if you do complete the process, you might find that your hard-won IP rights are worthless because, for example, they are too narrow or too specific. And this is your introduction to the value and role of a patent attorney. Let's look at the role of the patent attorney. In the first place, intellectual property attorneys, such patent and trademark attorneys, take you every step of the way through the application process. In addition, they help to identify and deliver the most value from your IP protection. Also, if anyone infringes your protected IP, your patent attorney will help enforce your legal ownership and seek compensation. Here are some of the areas of expertise provided by a patent attorney. We patent attorneys provide IP protection, especially for patents, trademarks, copyrights, and also of trade secrets. We draft patent and trademark applications. We prepare the legal filings of those. Then we settle IP disputes. We manage IP assets that can be very valuable for your company. We identify IP rights that are held by others. That's important because we need to find out whether you have a freedom to operate your business in view of these IP rights. Then we deal with licensing. That means you can derive income from your invention by licensing to others. Then we do asset transfers, if you sell your IP, for example, or if you purchase one. Then we also work with valuations to find out what is the real value of your IP right so that you can take it up into your balance sheet. And also, we deal with IP ownership issues, as they often arise between employees and employers. So, let us now examine the playground for the patent attorney in more detail when it comes to litigation. You know how litigation works about the patent. There is always a client who is an inventor and he has a patent and that patent has been infringed. The infringer doesn't want to pay license fee, and not to speak of stopping using the invention. So we need a high court to decide on the infringement case. The normal way for any litigation done at high court would lead through a lawyer or a barrister in the UK. A patent is a highly technical document and lawyers are usually not trained to cope with the language and the meaning that is represented in a patent. The solution to that is that we bring in a patent attorney. Optionally, of course, because if the lawyer feels fit to do the patent litigation himself, he would do it alone. But as soon as a patent attorney comes in, he would support the lawyer and the barrister with ammunition that is exclusively shot by the lawyer at the High Court. There are some countries like the UK or Germany who allow patent attorneys to plead in court if they have a special education to do so, but in Singapore that right is reserved exclusively to barristers. Now let's talk about patent prosecution. What most people do not know is that an inventor can talk directly with the patent office about patenting his invention. No patent attorney is needed and also no lawyer is needed to do so, but of course, if someone wants to do so, he can optionally hire a lawyer and then do all works at the patent office. And there is a third option available, which is the patent attorney, and of course it's optional again. The patent attorney would talk directly with the patent office. And there's a fourth route, of course, a lawyer. If he has an inventor as a client and he wants to work with the patent office, it's always a good idea to refer to a patent attorney who can also work in the background very often so that the lawyer shines in front of his client. Let's now talk about how the benefits of a patent attorney earn the investment into a patent application. The first and foremost advantage of having a patent attorney helping you with your patent prosecution is that you are much more likely to complete the application process. There will be much more to be said about that at a later time. Then also, you are faster and also more efficient in doing so, which means that you get your patents much earlier than doing them yourselves. Then it's easier to overcome objections of the patent office, which there are usually a lot, and also make sure that the granted rights are effective in scope, because a patent that is not effective doesn't help you. You have spent all the money in vain. Of course, there's also research done into how the patent attorney adds value to the process of innovation, and this was commissioned in 2013 by my organization, the FICPI, FICPI, the Trusted Global Community for Independent Patent Attorneys. By the way, we have over 5,000 members, so it's always good to have one of those patent attorneys helping you. That research is called the Heusel-Wagner report, looked more closely at the work of the European Patent Office. And in the following, I will present you what is the outcome of the Heusel-Wagner report. In the first place, the authors discovered that applicants that are not represented by a patent attorney are much more likely to lose rights simply by failing to understand the procedure or that a response is required. I find that quite amazing, because to me it looks like self-evident that you have to reply to a patent office communication when it comes up. The Heusel-Wagner report was commissioned as a part of a wider study by FICPI into the value added by IP practitioners to the innovation process. This is known as the Project Orange, after the name of the chairman, John Orange. You can download a brochure with fuller details of Project Orange's findings here, and I put the bit.ly linked bit.ly/IP-practitioner, and then you can download it from there. And here are the reasons why IP applications are more successful with the support of a patent attorney. The 2013 Heusel-Wagner report, which closely examined the workings of the European Patent Office (EPO), found that small corporate applicants rely on an independent patent attorneys more frequently than their larger counterparts. It is also found that applications that were represented by independent patent attorneys are granted at a much higher rate than filings with no professional representation at all. In addition, the patent application filed by an attorney is more likely to withstand opposition and challenges from competitors. As you know, a granted patent is not carved in stone, so after grant it can undergo some challenges, and having professional help for those is something that increases your chances of success tremendously. The Heusel-Wagner report also discovered that applications which had no professional representation at all are much more likely to be withdrawn during the process. These withdrawals happen right after the expensive filing fee had already been paid, and you will not get this fee reimbursed if you abandon your patent application. Many patent applications were withdrawn because the applicant did not respond to a correspondence from EPO. And in fact, of 50 such applicants in the study, only 19, which is only a mere 40%, were still active for the payment of the first renewal fees at the first year. That means that 60% of the self-made patent applications were dropped before the expiry of the second patent year. In the following, I wanted to show you 10 ways where an intellectual property attorney adds value to your intellectual property. In the first place, protecting your intellectual assets adds value and helps to grow your business. That's often overlooked. So the patents are not only a help in promoting your own business over your competition, but it also adds value that can be measured. The 10 ways that independent patent attorneys create that confidence and add expertise to the procurement of IP rights are as follows. First, the patent attorney helps you to identify the IP rights that potentially exist and can be protected. That's not obvious in the first place. Second, patent attorneys are familiar with a wide range of technologies because in their daily work they are not only confronted with one single range of technologies because they have more clients than one, but they have a wide range of technologies. And so it is very easy for them to identify synergies between other ranges of technologies and your own technology. Next, patent attorneys have an ability to describe and clearly define your innovation, and that's very important if you want to patent it. Patent attorneys are also trained to skillfully draft your patent application with appropriate breadth for the best protection. That's why we have to study between 3 and 5 years, and many of us have many more years of practice in doing so. Then, patent attorneys understand new technology to differentiate the innovation and extrapolate the potential future use. That is important to increase the value of your IP. Then, patent attorneys describe the innovation, hopefully, in a manner that is readily understood. That's also a good way to test your patent attorney. If you cannot understand what he is describing, then probably you're not with the right patent attorney. 7. Patent attorneys understand the legal balance of protecting the innovation while advancing the wider public interest of advancing economic development. It is very important to understand that, because a patent undergoes a grant process, and as a patent applicant you're in a constant battle to get a wider protection, while the patent office is there to balance that out with the public interest. Patent attorneys are also trained to balance the basic needs of the IP system with obtaining the protection to which the innovator is entitled. That goes very deep to the roots of patents, why there are patents, and how it works to get a patent from the government, which is, in other words, a monopoly that you can use against your competition. Patent attorneys are also trained to anticipate objections and infringements in other countries and regions. That's why we have an international network, and we undergo constant training where we learn about patent infringements overseas. And of course, patent attorneys are trained for knowing how to avoid the IP rights that are held by others, so that you have a freedom to operate in your own business. We have now heard what patent attorneys could do well for you and how they can improve your business. Now it's about how to find a patent attorney that fits for you. Actually, that should be a patent attorney with expertise in your idea's technical field. Here is the mistake that happens most often, or too often I would say. 90% of the entrepreneurs only ask about the initial price of a patent application. And that is complete nonsense. Your main objective is to first find a qualified patent attorney and only then to agree on a price. This is the rationale for that. A patent application is both a legal document and a technical document. So make sure that you find an attorney who is able to fully understand your invention at the most technical level, so that he can draft a document that fully and clearly describes it. And the emphasis here is at the most technical level. Look for a firm that has a patent attorney with the appropriate technical background, and consider asking specifically for that attorney when you contact the firm. Here are now 5 savvy questions to ask before you hire a patent attorney. First, there's a patent office metric, and it is the number of office actions. An office action is an official letter sent out by the patent office that objects your patent applications. That is a very normal thing to happen in the life of a patent application, because the patent office would verify whether your patent application fulfills all the requirements for being granted. And you should ask now, on average, how many office actions do you take to get a patent allowed? And now there's a hint. If the answer is 1, which means that only one office action would lead to a granted patent, then you should be careful with what you do. There is a very easy way to turn a patent application into a granted patent just by making it so narrow that there is no room for discussion about inventiveness or novelty. So if a patent attorney has an average of only one office action from filing a patent application to grant, then this can mean, but is not necessarily so, that he tends to limit the patent to a degree so that the patent examiner has nothing to discuss anymore. That patent can be too narrow. The same would happen if a patent attorney has an average number of office actions of 3 or more. That means that he just deals with the problems at hand with the first office action and then waits for the examiner to come up with further objections. That can lead to a very time-consuming and expensive process of obtaining a granted patent. The truth, and the healthy truth, is somewhere in the middle between 1 and 3. So a patent attorney with an average of about 1.5 office action from patent application filed to a patent granted is something that sounds healthy to me. I must admit that this is a very difficult criteria to judge, but at least you should try to find out. Next, is the patent attorney fluent in your technology? You should ask, what technical degree and what industry experience, if any, does the patent attorney have who is going to actually work on your case? And what I see often are physicists that directly come from university. They never had any industry experience at all. At most, they did a PhD at the same university, then enter the profession of a patent attorney, and then suddenly they work on all sorts of technologies. And these technologies often are very industrial. And that can, I don't see it must, but it can lead to very bad results. Next question. What is the average time to allowance? How do their clients' time to allowance compare to the average published by the patent office? You can look the average published by the patent office up in the patent office website, and then you just ask, what is your average time to allowance for your patent applications? And then you compare. If it's faster, good. If it's slower, depends. There are situations where you do not want a fast grant, so you need to ask. Business experience. You can ask, what processes do they specifically have in place to make a patent more commercially valuable? And many patent attorneys do not have any such processes in place, which shows me that they are not out for generating patents that can be used in litigation at a later time. Next one, patent litigation experience. You should ask, what roles in patent litigation wins did your future patent attorney have? That can be either on the patent owner side or also on the defendant side. So if you ask these 5 questions, you would immediately see where the whole process goes. And I would recommend that you talk carefully with your patent attorney before you give the order to draft a patent application. Let's now come to a few frequently asked questions when it comes to inventions. Question number 1. Is it true that good ideas are stolen or copied? And the clear answer is, some of the most famous inventions in history were based on stolen ideas. For example, the invention of the sewing machine is commonly attributed to Isaac Singer and the Singer corporations. But in fact, the design was originally patented by an inventor called Elias Howe, and following legal action, Singer was forced to pool its patents and share the royalties with Howe. Ironically, a gentleman called Walter Hunt had, even earlier, invented a sewing machine, but he did not patent it. You can read an article, 10 Great Business Ideas that were actually stolen, and the link is here, bit.ly stolen inventions, and then you can download it from there. Next, are counterfeits from China a problem for small businesses? I hear that often, and working in Asia, Singapore to be more exactly, and I'm often in China, and I can tell you today China has a very effective legal system to deal with the problem of IP protection. That may have been different in the past, but today China is one of the countries that is leading in the area of IP protection. And that is not only for registering IPs, but also for enforcing them in court. China has made the biggest leap of all the countries that I'm aware of in this respect. So today, China is Premier League when it is about IP protection. The problem is that this IP protection system is only effective if you applied for IP protection in the first place. Should be clear, right? But people often forget that. Look at the story of Ruth Bronze. She's a violin teacher in the US, and she invented an accessory to help students to hold the bow correctly. Ruth acquired the trademark Bow Hold Buddies, and she patented her invention in the US, in Canada, in Mexico, in Europe, even in Australia, but not in China. And now, when she planned to move to the China market, she discovered 2 factories that are already making counterfeit versions of her product, selling at a fraction of her price. You can read the full story of Ruth Bronze's expensive struggle to regain protection for her product in China here. bit.ly/counterfeits China. And then people often ask me, what is FICPI and how can it help small businesses protect their intellectual property? So, FICPI is the trusted global community of independent patent attorneys, trademark attorneys and lawyers that specialize in intellectual property in private practice. FICPI is an acronym and it stands for the French term Fédération Internationale des Conseils en Propriété Industrielle. It's International Association of IP Attorneys in the area of intellectual property. FICPI members know how to navigate the world of intellectual property and they assist small businesses in IP protection, drafting of applications, prepare legal filings, settlement of IP disputes, managing IP assets, licensing, asset transfers, valuations, and IP ownership issues. You can find a trusted IP attorney in your country or region by searching on our FICPI website, ficpi.org/member-search. So I'm now at the end of my talk, and if you take only one thing with you for the future, then I would like that it is this. What is a general practitioner? What is a surgeon? What is a lawyer? And what is a patent attorney? So please don't call us in the future lawyer when we are patent attorneys. Thank you and goodbye.